My name is Frank Ally. I'm a California attorney primarily focusing on family law issues. Now let's get started. Let's talk about child custody. In California, there's two types of custody. There is legal custody and there is physical custody. Legal custody refers to the right and responsibility to make decisions regarding the health, the education, and welfare of a child. Physical custody refers to time periods during which a child resides with, is under the supervision of a parent or other party. Legal and physical custody may be granted solely to one parent. This is called sole custody. It may also be awarded jointly to both parents. This is called joint custody. They don't have to be the same. One parent can have sole legal custody of a child and share joint physical custody of that same child. Also, a party can have joint legal custody of the child, but sole physical custody of that same child. I want to differentiate between physical custody and parenting time schedules. Where physical custody refers to the fact that a child is going to live in one home, sole physical custody, or two homes, joint physical custody, it doesn't actually define the specific times and exchange parameters of that custody. That would be covered under parenting time, which is another episode in this series of videos about California family law. If you want to learn about parenting time, including options for different types of parenting time, you want to click at the link above, where we're going to go into some detail about different parenting type plans. This is really important. There is not any preference or presumption in California for or against joint legal custody, joint physical custody, or for sole custody. The court and the family are given the widest discretion to choose a parenting plan that is in the best interest of the child. Just because you have a kid doesn't automatically mean you have a right to custody. We're going to discuss that further. It is also important to understand that custody orders can be temporary or permanent. Initially, in the beginning stages of a dissolution process, most parties either agree to a custody determination or the courts will determine it for them. The courts will use a number of different factors in determining what is the best plan for a particular child, but it's all focused on what is in the best interest of that child. This best interest of the child standard is, quote, an elusive guideline that bellies rigid definition. Its purpose is to maximize a child's opportunity to develop into a stable, well-adjusted adult. This best interest standard is a relative one. The question is not whether a particular set of circumstances is in the best interest of the child, but whether a particular set of circumstances in relation to an alternative set of circumstances is in the best interest of the child. The court must reference Family Code Section 3011 to determine what a child's best interest is. In determining the best interest of the child, the court must consider the length of the time that a child has been in the continuous physical custody of a parent who has custody at the time of the custody hearing. When a child has lived with one parent for a significant period, the need for continuity and stability will often dictate that maintaining the current arrangement is in that child's best interest. The court will also consider the preference of a child in determining that child's best interest. Now, it's not automatic that a child gets to decide who they're going to live with or who's going to make decisions for them. In fact, the courts really want to keep the children out of divorces, and the more likely a parent is to involve a child in a litigation, the more likely the court is going to start questioning whether that particular parent is acting in the best interest of the child. Family Code Section 3042 governs when and how a child must be allowed to address a court regarding the child's preference. Now, in general, Family Code Section 3042 governs when and how a child must be allowed to address a court regarding a child's preference as to custody and visitation. Family Code 32 provides that if a child is of sufficient age and capacity to reason so as to form an intelligent preference as to custody or visitation, the court shall consider and give due weight to the wishes of that child in making an order granting or modifying custody or visitation. This is discussing a child's ability to articulate mature reasoning for expressing a preference of custody. And the court is also very cognizant of influences of parents on children. We're going to dedicate another episode on the preference of the child. You can get to that clicking on the link above. We're also going to discuss possible influences on a child and their decision on whether to spend time with another parent in another video that we're going to discuss parental alienation, refuse-resist dynamics, and parent-child communication problems. Just because a child expresses a preference doesn't mean that preference is in the best interest of the child. And the court will carefully examine all aspects of that child's reasoning in making a decision. And it could happen, and I've seen it happen, that a child expresses a preference to go with one parent, and the court determines that that child has been unduly influenced to the extent where that child needs a protective separation from the parent to whom they prefer. So watch the videos that we've linked above. That could be very important here. Yet another factor the court will consider is siblings and separation of siblings. A court may enter a custody order that has the effect of separating siblings only when there's a compelling circumstance that dictates that the separation is in the children's best interest. So the courts are going to try their darndest to keep the kids together. This episode has discussed a number of factors involving legal and physical custody of children. Of course, it's much more detailed than can be presented in a short video, but this should give you a general guideline of where to start. The factors discussed in this episode are used to help determine a child's best interest and are generally looked at from a child standpoint. The court should not consider the feelings and desire of contesting parents except as they affect a child's best interest. One of the most difficult things about being a family law attorney is watching parents involve their children in their divorces. You have an obligation as a parent to protect your child, and that means protecting them from your own individual feelings towards the other parent. It involves an obligation of you not to use your pawn to get back at the other party or to punish the other party. The children come first, and I would ask you, whether you're my client or the client on the other side, please think of your children first. Let's do what's best for those kids. It'll be better for everybody. Divorce sucks, but eventually you're going to have to deal with it and get it over with. Divorces can be complicated or divorces can be easy. Knowledge of the law and knowledge of the process can make a complicated divorce easier. Drama and a lack of understanding can make an easy divorce more complicated. The more complicated we make a divorce, the more expensive it is and the more it's going to cost you, both in money and emotional well-being. This series of videos is calculated to help you gain the general knowledge that you need so you can understand the law and the process a little better. If you find these videos helpful, subscribe to our station. If you know somebody who's going through the process and you're not sure how to help them, consider having them subscribe to us as well. My name is Frank Ally, and I'm your ally in family law. Thank you.